Well, welcome everybody. I have with me Jason Moy. He is with Cordatus. That's how you say it?
Cordatus, yep.
Cordatus. That's how you do it. Quick disclaimer before we get started. You can read the top part. It says provided to you for educational purposes. The second part is saying it's not going to guarantee you nothing and it's being recorded. So there you have it. And we will distribute the recording after that. Session agenda today. We'll give you some introductions on what we're doing. We're talking about equitable adjustments throughout this process and all of the rest of the pieces with government changes. How do they deal with that? How you can request one, and what happens if you get denied, and what is a contract claim, and what's the difference between those and an equitable adjustment. And we'll be getting right into that. If you are here for the first time and you have no idea how Zoom works, you can go up to the top and turn it into a side-by-side so you can watch the presentation at the same time, or you can make it disappear altogether just by this little doodah thing. That's a very scientific term, and you can make that work. If you would like to communicate with us, we have a fair amount here. There's 50 folks. So do us a favor. If there's anything that you want to know about music and anything else that we went there, we'll put our stuff that are handouts. There's going to be only one handout today, and that's this briefing itself. And that'll be popped into the chat. If you want to ask questions, you can raise your hands or pop it in the Q&A. And that way we can keep things semi-organized, at least. And we will also be prodding you for massive amounts of audience participation, because we want to make sure that you're getting what you want out of this. And you can just pop in here and say, what in the world made you decide to come here? I have a contract that is underwater and need equitable adjustment, trying to get my hands around this whole thing, or my boss thinks I need to know this stuff. Love the fact that we have some Weisenheimers here today, Jason Moy. Yes. You can choose as many as you want, because that's just how flexible we are. And while they're doing that, tell us a little bit about Cordatus. And we know that you were formed in 1979, but you weren't there in 1979.
No, I was not. But
you were
since
at the Tool
1979,
concert.
Yeah. Actually, it was more like 1999.
Oh man, so am I.
But Cordatus is, obviously we've been around for about, over, since 1979. So been around for a year. We have, some of the original founding members are still here. And what that does is it gives us this huge depth of experience in government contracts. And we're really known for our bid protest services, for government claims processing and compliance. We represent all types of businesses, all the way from Fortune 500 down to small businesses just starting out. And, in addition to what we do in our government contracts practice, we have a national security practice. We also help a lot with federal programs for small businesses, construction law, corporate law, IP, right? So a lot of, services. So if it touches government contracting, that's something that we help out with.
Yeah. And I just want to throw out that Jason is a wealth of knowledge when it comes to the government contracting world. When I got involved in this way back in 2009, I've been looking for folks that really understand the federal contracting world, because it doesn't operate the same way as commercial. Shocking as that is. But yeah, it is so important to have somebody like Jason just as a resource, and the resource, and you have him as a resource now. So it's going to be great. So appreciate that. Going to get over 3, 2, 1. And here's what we got. 42 out of the 50 people. We won't call the other ones any names for not answering, but we will say that there's a lot of folks who are just trying to understand how to ask for an equitable adjustment. And that's the vast majority, although some of those have a contract that's underwater right now. We know that that's an issue, right?
Right.
There's a lot of reasons for that. And hopefully we can answer some of those, and some of the answers you're not going to like. I'm telling you that right now, because Jason already told me some of the answers, but we can also get what we can, right? So let's start with, what in the world are we talking about here? What is an equitable adjustment?
Yeah, so it's not a term defined in the FAR. The FAR section 2 has all these definitions. It's not defined there, but there's a general accepted agreement about what it is. And you can find this term throughout the FAR. It's mentioned multiple times. But I think the best definition comes from this book by Ralph C. Nash. And it's a fair price adjustment under a contract clause for changed work, including adjustment in profit, a change in the delivery schedule, if appropriate, and a change in other affected terms of the contract. And that's really what it is. Really what you're focused on here is the change. So something changed in this contract that resulted in, hey, an increase or decrease in price and or the delivery schedule, or what is going to be a deliverable under the contract. And so, hey, we've got to adjust something. Next slide.
Okay, that's awesome. I didn't know this one.
So another way it's been defined, and this is from the Armed Services Board of Contract Appeals, or the ASBCA, broadly speaking, an equitable adjustment is a request, and we're going to talk about that in a little bit, from a contractor to a contracting officer to consider adjusting the contract terms. And that could be, again, price, it could be delivery schedule, period of performance, a deliverable, whatever it might be. And because they're non-adversarial, this is a negotiation. This is opening the door to a negotiation with the contracting officer. And you might want to do that because once you submit a claim, boom, the adversarial wall comes up. That contracting officer is going to go to his attorney, whatever agency attorney, and bring it to them. And they're going to look, hey, is there a litigation risk here? Is there something where the government thinks, oh my gosh, if we don't settle this, we could wind up having to pay a claim. And then that's how that route goes. With those agency attorneys, again, they vary, from whatever agency. Sometimes they're easy to work with. Sometimes they can be really trying to be, difficult to work with. And I see a question there, CDA claim, just real quick. A CDA claim is a Contract Disputes Act claim. That's where you say, hey, the government has breached the terms of the contract. I'm filing a claim against the government in order to get contract damages, right? So different from the equitable adjustment. That is, hey, we're going to start a conversation. We think that there's been a change in the contract. We want to adjust the price. So thinking about those changes, what are we looking at for changes right now? A price increase. And if you look at the FAR, a price decrease. What happens when the government says, hey, we're going to cancel some of this work? Hey, we no longer need food services in building H. Hey, we no longer need you to remove these 10 trees. Whatever it might be. If you've bid a price to do that work and the government then removes that work, the government can come back and decrease the price. And again, that's something where you might want to be like, wait a second, are they taking too much? Are they removing too much of the price from this? Or are they adding more work and taking some away? Is it a mixture? It can also be a change in delivery schedule or the period of performance. It can be a substitution of contract deliverables. Hey, we wanted you to provide widget A, now we want widget B, or widget A, model 3.1, whatever it might be. And then also think about this. What about if the government does breach the contract? Can you not ask for an equitable adjustment in a term when the government, say, for example, doesn't provide you information it promised to provide you in the solicitation, or that the government told you to work in this particular location that it never provided to you, right? So again, if there's a breach, yes, you can say, hey, look, you haven't provided this information, you haven't provided this workspace, you haven't provided this government property you say that you said you're going to provide. Now you can go and say, hey, look, we need an adjustment on that. Also, think about this. When you're thinking about what it is, just the change by itself, if that change results in zero adjustment in price or change, like instead of we want this in a different color and it's going to cost you $0 and additional time to produce, say, something in black versus something in white, that would not necessarily be considered an equitable adjustment because there's nothing there to adjust. Again, thinking about that, if there is a price adjustment, you're looking at a fair amount. This is supposed to be equitable, right? Fair, reasonable. So next. It's handled through the changes clause of the contract. Almost every contract, I can't imagine a contract that doesn't have a changes clause in it because, well, the government changes stuff. And
the government changes stuff?
Amazing. They will do it. And they have a method to do it, and it's usually part of your contract. And this is just an example of one, but I highlighted some words there that if they make this change and it does result in an increased price or difference in the schedule, the contracting officer shall make an equitable adjustment, right? And so sometimes, like, they've got a mandate to do it.
That's the word.
Shall modify, right? Yeah. So that is a helpful tidbit here, because if you're seeing contract changes, and the CO or the COR saying, hey, we're not trying to give you any more money, but you're like, yeah, but this change is going to cause me to spend more. It's going to cost more to perform. that's when you need to start thinking, okay, I really need to consider putting an equitable adjustment here, because otherwise I'm not going to get any additional funds. So we talked about this idea of a request versus a demand, and this is kind of go back to that, hey, what contract claim versus what an equitable adjustment is. It's a request, right? Hey, contract officer, here's my issue. Can you please, we respectfully request that you adjust the contracting price or the time of performance, whatever it is. Here's our math. Here's where it shows that this is going to increase our cost of performance based on your change. A contract claim under the Contract Disputes Act is different. It is a written demand or assertion by one of the contracting parties as a matter of right, the payment of money in a sum certain based on the interpretation or adjustment of contract terms relating out of the contract. And there's a whole, there's a statute, Contract Disputes Act, that governs how those are processed. But that's important to know, because as we get later into the show, if the government denies your equitable adjustment, it turns into a contract dispute. So you got to know how this process works.
Interesting.
Yeah.
And we do have some questions. I'll get to those in just a minute, I promise.
Yeah. So differences between the adjustment and the claim, just kind of continuing on that. An equitable adjustment doesn't require that you have a certification. And the certification we'll get into later when we talk about claims is to kind of root out fraud. But if it's over $100,000, you got to certify that you're making a good claim. Now, the one caveat to that is if you're in a DoD contract and it's over $150,000, your requested change, then you do have to certify your equitable adjustment.
What does that mean to certify? What does that mean?
Yeah. So it's basically a statement by someone from the company that's in charge, and that can bind the company to say, I certify that this claim is a true claim for X number of dollars. And what that does is supposed to be like, aha, you wouldn't certify it if you were submitting a false claim. It's just one way the government can say, look, you said this was correct. And let's say, and there's actually cases where this has occurred, and I cited one later on, where the government discovered that the request for an equitable adjustment was done in fraud. And so not only did the government reject the claim that this person later made, that guy went to jail for violating the False Claims Act. Right?
Yowzers.
Yeah.
You want to stay away from jail.
Yeah. So again, this is something where, be certain that you actually have something before you start sending these things off, because you don't want to send a false claim to the government. That's bad news.
Bad news.
So again, we talked about the source changes clause versus the Contract Disputes Act, right? Equitable adjustment is from the changes clause, and claims are from the Contract Disputes Act. Now, with an equitable adjustment, there's no final decision required by the contracting officer. But the one caveat to that is they don't have a deadline to respond to you as well. And for a claim, they have to respond to you within 60 days. And there's some wiggle room the government has there, but roughly 60 days. And the problem is, what we see a lot is that people will submit what they think is a request for an equitable adjustment, but they have certification language in there. And the courts have held that if it walks like a duck, looks like a duck, quacks like a duck, it's a duck. Mm-hmm. So you can see here on some of these citations I have here, one is from the Court of Federal Claims, that something was styled as an REA. The memo is titled Request for Equitable Adjustment, but they requested a CO final answer, which is not part of an equitable adjustment. And it was held to be a claim. That has certain legal significance for timelines, for if you can get fees, for example, attorney's fees, because there are some way to get fees back from some of these processes. And then there's another case there, BAA Systems Ordinance. They did not, the Army was trying to push it to be a claim, even though it was stylized as an REA. And the ASBCA rejected the government's argument, said because they didn't request a CO final decision. So it does matter what it goes into these equitable adjustments, because it can dictate how the courts and how the boards will review them.
So just so that I'm getting what you're saying. So based on the words that you're using to say, that can also make it look like the duck, and that being a contract dispute, which then raises the defensive walls, right? And because then it becomes adversarial if you use the wrong language.
Yes. And the big thing is that if you submit a claim, there's certain timelines you have to follow versus if submitting an equitable adjustment. And it could very well sometimes happens that someone thinks they're submitting an REA, it's viewed as a claim, and then their case gets dismissed.
An REA is request for an equitable adjustment.
That's right. Yeah, I'm sorry. Yeah, request for equitable adjustment.
You said it. You already said it once, but I want to reinforce that because that's a new term for me, just in case we don't have enough acronyms when we're talking about government work.
Yes, of course. Right. So as I mentioned, there are certain circumstances where a contractor can receive compensation for the work to prepare an REA. That is not considered a claim. But if it's a claim, that's cut off. So if you are preparing a claim, like you got to hire expert witnesses, an accountant, all these other folks, you want an attorney to help you prepare the equitable adjustment, you can sometimes get some compensation for that. I caveat that because a lot of times the government doesn't want to pay it, and they'll say like, well, we'll give you what you want, but you have to give up your claims for costs. So again, it becomes a negotiation process. But if you're in a claims environment, that does not exist, right? And there's another avenue, though. If you go through a claims process, you can also possibly get what we call equal access to justice fees. So there's another way to get it. You have to win, right? And so the government doesn't usually like letting you win. And winning under that Equal Access to Justice Act is slightly, it's not exactly as you might think.
I'm going to quote you on that. The government doesn't usually like letting you win. I love that.
Not on that aspect. They want to go to a settlement. Because if you settle out, there's some case law out there that says a settlement doesn't count as a win. And it depends on what jurisdiction you're in. It would really be on the scope of this webinar to discuss all the ins and outs of the Equal Access to Justice fees. But yeah, sometimes a settlement is not considered a win by the government, and that means they don't have to pay your legal fees. And that's sometimes where they'll go, how they'll go.
So I first of all, I really appreciate this because I'm learning as we go too, because this is not my world. My world is not this.
Yes.
So I love this because now I love negotiations though, because negotiations revolve around relationships and being able to have a give and take with what is reasonable.
Right.
And a lot of most folks are reasonable most of the time.
Absolutely.
And one of the ways that I heard is to keep people reasonable is not to make it look like it's going to be a claim. It can always escalate to that, right? That's what you said.
You can always escalate it. Mm-hmm.
But if you keep it relational, oftentimes, what is that? You get more from sugar from vinegar or whatever you want to say.
Right. Absolutely.
Yeah. I like that. All right. So this question this poll is going to be one of the questions I know everybody is asking, or a lot of people are asking. So here's the deal. I think I'm due, or I hope I'm due. Let's put that. We can even put it that way. I hope I'm due an equitable adjustment because the CO changed the contract and increased my cost. The government has not provided me with information that was important or to the program. The government has delayed the project or freaking such a fraction inflation, right? And what type of contract is it that we're talking about? So that way we can get into, so we have firm fixed price, right? Inflation, right? You can pick that. And we're going to talk specifically about that. And let me get to a couple of questions here because there's some in here that I will say, hold on. The link did not give me the presentation, but rather a page with a lot of headings that don't relate to my specific things. Zachary, can you check the handout page for the presentation? Make sure it is correct. Thank you very much for that feedback. We will make sure we correct that. Is there an efficient way to encourage the Gov to respond to REAs in a timely manner other than filing a CDA claim? Second part, is there any further REA to request for Gov failure to respond timely to an REA? Very interesting way to question that, right? Because you already said that there isn't a time frame for it per se, but
that's right. But there are ways, and what I'll tell you is the most efficient way to encourage a response from the government is to provide them with a nice REA, an REA that contains the information that the government needs. Because you got to remember that contracting officer who is receiving this REA has to justify his or her decision. And if you give them a bare bones document with not a whole lot of meat to go on, that contraction officer might be like, I don't know if I've got enough here. He's trying to cover his or her own butt as well.
That's right.
And so, and giving them this full disclosure of like, hey, here's why, here's how, here's this, here's that, you can actually get a response quicker. On your second part, is there any further REA? I mean, you can the problem is the unsqueaky wheel gets the grease kind of thing.
Yeah.
If you have a REA and the government's just like, I'm never going to respond to this, and it's been months. I mean, like, again, don't let it go that long. Right. But if you haven't heard anything back, that's the time you need to start like pinging, hey, looking for an answer, just something to please acknowledge that you received this. Is there any other information that you need that would help you make this decision? What else can we provide? Is there opportunity to hop on the phone and talk about this? You just got to be that squeaky wheel. But no, there's not. The government fails to respond to your REA. You may have increased costs. You may have additional costs that keep coming up, and you might want to request a second REA based on this continued.
Oh, nice move! Yeah. Nice move. I like that move. Yeah. So a second REA because you didn't respond to the first REA,
right.
And then, that's a good move.
Because if it's been a long time, your costs are still increasing, they're still going up due to these changes. You may also need to do another claim or REA for those costs as well. So,
all right. So real quick, I do have another one that Matt Anderson has in there but I'm going to end this poll and we're going to answer the elephant in the room. Right? The elephant in the room is inflation, right?
Yeah.
So answer that one so that everybody can get the big groans out right now. Go ahead.
Yeah. So most of the respondents here, 79% stated that they have a firm fixed price contract. And the issue with that is that places maximum risk on the contractor, on you, not the government. And so when that's the case, the government has, even though they might feel sorry for it, they might feel bad, they can't do anything. In fact, the DoD submitted a memo, I don't know, maybe sometime late May, early June, that basically said contracting officers are not authorized in a firm fixed price contract to adjust the terms of the contract based on inflation.
Wow.
So it's, yes.
Wow.
They encourage, though, the use going forward of firm fixed price with economic price adjustment clauses. Because again, economic price adjustment clause is what would give the government some flexibility to say, if you've got a commodity that is just getting hammered, metal, wood products, lumber, right?
Good grief.
Something that's just, or you have to use a lot of fuel, right? I mean, gas prices, come on. That could help you. But right now, it's tough. Now, that's not to say all hope is gone.
That's right.
Because I'm sure if you get creative enough, you can find some ways where the government has delayed the project. The government has not provided you information that they were supposed to. The government changed something. Somebody out there, the COR, somebody had you do something that maybe wasn't necessarily by the terms of the contract. Oh, and by the way, maybe there's just a difference of interpretation of the contract terms. And that also can get you in the door for an equitable adjustment.
And you had, this is something I know you're going to say, is you don't ask, you don't get. That's the first thing.
Yeah.
And we are talking about trying to work with reasonability. And while they're bound by the contract language, that doesn't mean that we can't find ways to be able to help each other when we want to help each other, right? Isn't that true?
That's right. Absolutely. And look, it might even be just like, hey, we understand you have a loss. And if we continue this current delivery schedule, you're going to have a huge amount of loss in a short period of time.
Right.
Let's extend the delivery schedule. So at least you can take that loss over a longer period of time to help the business. Because the government does not want to see you go out of business, right? They don't want to see that.
No, that doesn't help anybody.
That doesn't help anyone, right? So if they can do things that will help, they will do it. So it doesn't necessarily have to always mean additional money. It could be ways to delay the project until prices come down. And again, you've seen the government do this already with supply chain issues. they know, they understand that there's things that just are difficult to get now.
Yeah.
So again, it is something where you can do these requests for adjustment, ask for something, be reasonable, have your tug at their heartstrings, and potentially come away with something other than, maybe you get something, maybe
Right.
not the whole 9% inflation, right? But
Right.
maybe you get something out of it.
So we're going to get into what contract changes are in just a minute. But so Matt said, so we should not ask the CO for a response in the body of the REA, right? And I'm not sure that's the answer either. You want a response from the CO.
Yeah, so that's a great question.
Finalized run, right?
Right. That's a great question, because what happens in some of those cases I mentioned is that they stylize the REA with the exact kind of language and verbiage you would in a claim, asking for,
because that was done by a claims lawyer,
maybe, or maybe by someone that thought they were doing it right, but either one, they didn't know.
Way to defend the lawyers, man.
Yeah. Well, it's my profession, but so you don't want to ask for the contracting officer's final decision, but you're like, can you please respond by X date, in there. That's not going to be considered asking for a contracting officer's final decision. Or maybe you say, would love to discuss this with you. Please let us know a time that you'd be willing, that you have some time to talk about this issue. So you're staying away, you're steering clear of that language that could potentially some agency lawyer can get creative with and say, aha, this was really a claim and you're late. And so
gotcha.
Try to cancel your.
And Joseph Lee says, but to win when you know the government is wrong and has acted in bad faith, would it be best to say, no, we want to push forward and not settle? That's a business.
Yeah, I think if in that kind of that hypothetical, if the government's acting in bad faith, they're not going to care about your REA. They're just going to let it sit there. They're going to put it in their desk drawer and they're going to forget about it.
Right. Speaking of that, Joseph says when they're in the dark and no communication for months, they continue to stall. What can be done?
At that point, I think that you have to make a decision of whether or not you want to elevate this to a claim, because at that point, if you're getting nothing back, you've got your answer there from the contracting officer about how willing that person is to negotiate with you. They're not. And so they're saying, hey, you got to push this to a claim. And something you might want to do is say, hey, look, I haven't had a response for X number of months. And unless I get a response by X date, I'm going to file a claim. Or the next step is we'll consider filing a claim, something like that, where the contracting officer knows. And so if there's any shred, if there's any want from that contracting officer to actually go through the REA process, they should respond by then. And if not, I would tell you that, hey, if you're going to say you're going to follow up with a claim, you should probably do that. Otherwise, they're going to be like, this guy, he all talk, no bites. So again, if you're going to make a letter where you're going to say, or an email that says, hey, we're going to do this, you should follow through. And again, if it sounds like you haven't gotten anything from this contracting officer, it sounds like they don't want to negotiate with you. And maybe that's the best option.
So are we having trouble with the downloads? I see some folks can get it and then other folks can't. So no matter what, you will get the presentation, and when we're done, we'll make sure you get that. Every once in a while we have technical problems. Hey, internet. All right. So we'll continue those conversations and questions. And Joseph, we may even get you to a place where we unmute you in the future. But let's see if we can get through this, and we'll keep cooking. And what are the contract changes so that people know what you can look for? The Christmas tree you can hang your stuff on. That's what you're saying here, right?
That's right. That's right. Look, it's sometimes not straightforward. We're going to get into constructive changes.
No way. The government's not straightforward.
Sometimes it is, right? Sometimes it's not. Yeah, I agree. It can be frustrating because, the government is this huge bureaucracy who has all these people, and they might be telling you 10 different things, and which one has the authority to tell you what to do, and who's making your life miserable if you don't follow what they're telling you to do. And so, oh my gosh, was this a change or not? And you might think, I don't think the contract says that. They think we think the contract says that. So again, there can be different ways, but straightforward, it's a change that is made to perform additional work. Sometimes can be deleting work, modifying the work. And again, contract changes occur all the time. because government contracts aren't always perfect when awarded. Things change, and the government's needs may change, right? So
you got one here with circumstances with COVID-19. That's a change,
right?
Yeah.
That's again, you can't anticipate these things happening.
Right.
You can't anticipate. Let's say gosh, Dave, we were just talking about in the news. Let's just say could you anticipate that Russia would invade Ukraine? Could you anticipate that the Sri Lanka, right? And what if you have a service for over there for embassy, contract to provide food or to provide security or whatever it might be? There's a changed circumstance there, right?
You think
that's going to alter how that contract is run?
That's exactly.
So things happen, right?
So let's talk about the methods. What are they?
Yeah. So typically the government wants to do a bilateral contract change. Hey, contractor, we got to change the contract for these reasons. Can you submit a proposal for for these increased changes? Or, hey, we're going to remove some of this work, or, hey, we want to modify this. Can you let us know what you think about this proposal? And then you guys you negotiate, you come up with an agreement. Easy, nice. Sometimes the contracting officer will say no, I'm just making this unilateral change. You got to eat it. And they may not know the second and third order effects that may have in your business. The contracting officer may think this is not going to cause any additional issues. Let's say we wanted to change the color of, for example, a piece of equipment from black to white. But it just so happens because of a supply chain issue, the price of black is 3 times as high as the price of white. And now you're like, but this is going to cost me so much more to produce the same thing that you want. Lastly, you have this informal, what we usually call a constructive contract change. That is any change affected through other than the formal means, right? All of these should be in writing. Anytime the government changes a contract, it should be in writing. But sometimes, verbally or through government action or whatever, you will find that they've constructively changed the contract. And that can have a lot of effects on how profitable or how good the contract is, or if you're going to now lose money on this contract.
I love this wiggle room. Changes can be administrative or substantive.
Yes.
So your approach sounds to me like the language of your approach of saying, hey, can we find a place where there's this type of change, administrative or substantive? Maybe you're not, going and poking the contracting officer in the eye. You're kind of poking the system in the eye, right? So
yeah, sure.
Kind of defraying some of the risk, because the contracting officers are all risk averse and they're going to get defensive before that's going to be their default, right? Because they're going to be like, I got to defend myself because I'm at risk.
Yes, they're going to come, it's just an administrative change. No need to worry about that. You're going to be like, no. This is actually substantive and here's why.
Okay.
Yeah.
Love it.
Mm-hmm.
And so the other part is authorized and unauthorized. What is this?
Right. So look, only the contracting officer has the authority to change the contract, but we all know that the COR, COTR, or other personnel in the government offices will sometimes come around and ask you for something different. And sometimes you might think, hey, these people want me to change the contract. And okay, they seem like they have the color of authority and you do it. If someone does that, you have to report that change. So if someone says, I want you to change this contract deliverable date, I want you to change this version of the software, I want you to change something, got to go to the contracting officer in writing and confirm whether or not the contracting officer ordered that change. It's very important, because otherwise contracting officer will be like, you volunteered these services to the United States government. Thank you for your valuable contribution to our country. You don't want
that. I guarantee you they're going to do that if you let them.
Yep. We kind of talked about this already. Preferences for the bilateral agreements versus unilateral changes. Unilateral changes, they tend to be just administrative, but if that changes the time of performance, the location of delivery, and I've got to now move these things 500 more miles with, record gas prices, they may try to claim that's an administrative change, but that's definitely going to hit the pocketbook.
Darn right.
So that's something you want to make sure that you're watching out for.
And how do you go ahead? Sorry. No, I was going to say, how do you make the change? You're going to get to that.
Yeah. How do you make the change? How does this problem? Okay, you've got the change. So there should be, what the contract now should give you is this amendment of contract, standard form 30. Make sure you're doing this before final payment. Like, hey, get this in writing. If you think there's a change, the contracting officer should give it to you in writing. And if you don't have this, get it. And there should be in there, sometimes you don't need to even go through the equitable adjustment process because you've already negotiated this change out. You're going to get a fair amount for the additional work that the government is asking you to do. And it's written right in this contract mod that they're going to put an additional $100,000 on that CLIN and you're good to go.
Yeah.
Sometimes though, they can say, hey, we're going to remove some of this money from the contract, and be very careful when you accept those changes to remove funds from the contract, because it's hard to get them to come back.
Oh, no doubt about that. All right. So constructive changes. Love this. Hit us with the constructive changes.
So it's again, oral written communication, act or omission by the contracting officer or other authorized government official that is construed to having the same effect as a written change order. And again, constructive change occurs when the contract work is in fact changed, but the procedures for that change have not been followed. That's really what you're looking at here. The government did not follow what they were supposed to do, and yet they made a change. And that would be considered a constructive change.
All right. Love that.
So there's three elements to this. Okay. Hey, you have the change occurred, as you said, from the government's words or conduct. The contractor change performance was not volunteered. And this is what we talked about a little bit, but as a result of the official's discretion. So again, if I'm like, hey, I can this wall needs to be repainted. It's really dirty. 10 people have had this office. There's holes all over. I'm going to patch this wall and paint it and say this is great. If the government didn't tell you to do that, you volunteered that service to the government, and they're going to be happy, but they're not going to pay you for it. Mm-hmm. And then this change has to result in an increase or decrease, if the government's doing it, in the cost or time of performance. So again, you still have to have that increase, because they could do a constructive change, and if it literally costs you no additional dollars, mm-hmm. no additional time to produce the work, you're not going to get any type of.
And you can't just do it on verbal, right? You have to make sure that you get this.
Once you get if you get something verbal, that's when you're going to the CO. Like, hey, the COR just verbally told me to do X, Y, and Z. We don't believe that actually is required under the contract. Did you authorize this change? If so, can we follow the contract change procedure?
Mm-hmm. Love it.
So, and again, there you go. Required to alert.
I jumped.
Contracting officer if they believe there's a change. And that contracting officer can ratify the conduct, like, yep, that's good to go. We want to do this.
All right.
And then they're required to do an equitable adjustment. They can reject the change, or they can say, we asked you to do that, but that didn't change anything. What are you talking about? And so that's when this negotiation process may start for you.
And here's one: CO's silence. No way. You mean they can be quiet?
Yeah. So sometimes, like, we're talking about, hey, the CO is not responding to the request for equitable adjustment. Well, let's say you notify the CO of a change in the contract, and the CO doesn't agree to the change and then requires you to continue to perform. You can say, hey, I'm going to perform this under protest. And if the CO doesn't say anything about you performing under protest, right? There's a long chain of things here, right? So you're saying, look, I'm going to do this only because you're telling me. I'm going to do it under protest. And the CO is like, okay, right? Then the CO is ratifying that change, right?
Wow. So by you saying that, I'm doing it under protest, they're saying you're going to do it anyway. So the CO is saying you have to do it. That's what I just
heard. So you're going to say, you're doing it, and it doesn't, because at that point, if you say I'm performing under protest, the CO should be like, okay, whoa, let's stop and talk about this. Don't perform, for example. Don't perform that until we agree that this is, we get to the bottom of this. But if the CO is silent on that, just doesn't notify you to stop performance, they've ratified the contract by silence. And then you protest it under you're performing under protest, meaning that you can come back and file that REA. You can come back and file that claim if it turns into that.
Gotcha. Fantastic. So different common types of constructive changes right here.
Yeah. So we've kind of touched on a few of these throughout. Contract interpretation. The government may think the contract says one thing, you think it says another thing. And because of this disagreement, the government's asking you to do something more. you're like, I don't think the contract requires me to do that. So it can lead to a constructive change. Defective specifications, right? So the government has various types of specifications they provide, but what if those specifications aren't good? It's not going to fix the problem. It's a complex, engineering problem, a building, something of that nature, where they're saying you need to build it to these specifications, and you're like, yeah, but that's going to make it impossible to perform, or it's going to, cause other issues down the road, for example. That could be considered a constructive change.
And I think there's a lot in here, because contracting officers' responsibilities is to execute contract actions. Right. Their responsibilities is not to understand how difficult these things are to complete, because they don't really understand those things. And so you're having natural, almost a tension here. You got to be careful not to call somebody stupid, right? Because it's like, hey, you don't understand, but you have to be able to educate them on how this is impacting them and how this change, while it looks like a very small thing or maybe just a couple of words in a contract, that can then, you can help them understand and say, you can just by saying I have to do this right here cost me an extra $15,000. So I need a way for us to be able to reconcile this. And oftentimes explaining the why to somebody, in fact, that's what all of our lives should be, is, hey, this is why we're doing this. Without getting combative, because as soon as you get combative, you're going to wind up having trouble, right? Right.
And again, it depends on the contracting officer. Some of them are going to be easy to work with, some aren't.
That's right.
But yeah, explaining the why is great, because it's educational. It's like, hey, here's the situation. Here's why without this, it's going to either that your system might not work. You need to really take a look at these specifications. We've hired outside firms, take this to, the agencies, engineer, whatever they might have, to figure out why there is a defective specification.
And that goes to, it's interesting you say that, because I've used this in the commercial setting. So you have to adjust me if this doesn't work in this setting. Yeah. But a lot of times they'll say, this is what the contract says. And I was, look, I just want to fix the problem. What we noticed is that this isn't going to work, or somebody notices it's not going to work. And you say, okay, let's work on how we can complete this and what it will take to be able to complete it. And that way you're both on the same side working together, as opposed to, and taking that to the engineer and say, hey, why don't we go to the engineer? You and I take this to the engineer and we say, does this pass the sniff test? Because if it doesn't pass the sniff test, then kick me to the curb. But then it's kind of a unified effort of everybody trying to solve the problem, as opposed to getting into a combative situation. That's just thought.
Yeah, I think that fits in this scenario, in these scenarios.
Yeah. Yeah. So what do you do when there's a contract change? First things to do?
Look,
go reach out to somebody.
I'm a lawyer, right? So I'm gonna say, hey, you should probably seek legal advice. And as Dave
self-serving.
Well, but as you mentioned earlier, that I'm not a resource. Look, call me, right? Email me. If you think there's something that you just want to bounce something off someone, look, I'm happy to take a look. No charge. And just kind of figure out, hey, if there's something there. But if you don't want to go that route, that's fine as well. What you need to do is start gathering the data to support your increase. And so, like, how is this costing you more money? And recognize that if this is a over $700,000 change, you need to have certified cost or pricing data for that. Consider filing the request for equitable adjustment, or for your costs or for the delivery schedule. Again, if you think there's a constructive change, notify the CO. That is step one, always, and don't delay on that. If you wait too long. Again, I think it's, there's some timelines here, but if you wait over, 30 days, there's really, it's fuzzy.
It starts to get difficult.
Yeah.
The sooner you start hitting the problems, the better off you
are. And then look, ask yourself, hey, should I be filing a claim or should I be filing an REA? And there's, I think we have a slide. The next slide is covering a little bit about that. No, it's coming up.
It's coming up.
So one of the best practices I like to talk about is always copying the CO on your correspondence related to the contract. the contracting officer may tell you, stop doing this. And you're like, no, I just want to make sure you know what's going on. Because again, we're talking about a huge bureaucracy. The contracting officer has a representative. That person may not necessarily always communicate with the CO. And what you're doing is you're providing notice to the CO. So if you get into this habit of always doing it, the CO is going to realize like, oh, hey, you just notified me that this contracting officer, my representative, asked you to do X. I don't want that to happen. And then later, if this does become more of an issue, you can show the CO was on notice because you provided the email to the CO. So here we go. So determine whether the REA or the claim is best. Look, you could go either way. You don't have to go through the REA process. You can go straight to a claim. Some people do, and some reasons why you might want to do that. We talked about already. Speed. Claims require an answer by a certain date. It forces the government to give you an answer. REAs don't. So if this is something where speed is a factor, and typically it is, maybe go with the claim. The relationship with the CO. If you think that the CO is operating in bad faith or is just really hates your company for some reason, do you think he's going to be interested in, or he or she's going to be interested in a settlement? Perhaps going through a claim is better. And then legal fees, right, versus CDA interest. Yep. We talked about legal fees. It's possible to get some of that legal fees in an REA. But like I said, the government will typically say, well, we'll give you the full ask of what you want, but we're not going to give you anything for your fees, your legal fees or consulting fees.
So what I just heard there is government hates lawyers. That's what I heard.
Yeah, and except for their own, they love their own.
That's right.
Yeah.
All right. So we're going to get to some questions in just a second, I promise. Have you requested an equitable adjustment? Yes, they accepted it. Yes, we're negotiating now, or yes, and it was denied, or not yet. And so there you have it. So I'm going to go to, there's a couple in the chat, and I thought somebody had their hand raised, but let's go to the Q&A. If you posted something in the chat, do me a favor, repost it in the Q&A so we can make sure everybody get this. Can you ask for an EA and for inflation on an FFF contract? We answered that, Aaron, and I'm sorry to say that you can't ask for it for just inflation alone, but
get creative. There's got to be something that the government's done. And even if it is just an inflation process, if you can support like, hey, an extending of delivery schedule or whatever it might be, there still might be some way. And look, even we have a claim right now going on that's settling, hopefully, where it was a firm fixed price contract. And it's based on the cost of materials rising. And the government came back, gave us a little bit, not this, a little bit. But you know what? It's better than nothing. Better than nothing. Right.
And always, you don't ask, you don't get. The more creative you get in your ask, the more you can get. That's the way life is.
Just creative, not to the extent that it becomes a false claim, though, right? So,
that's right. No, false claims get you thrown into the pokey. Does an REA that is not accepted by the government require a final determination letter from the KO before moving to a CDA claim? If KO is also CO, depending on what you are. Obviously, Enrique is doing DOD work. Just saying. So, before moving to a CDA claim?
No, they don't have to tell you that. You don't have to wait for them to tell you it's denied. If it's been a long time, you can just say, okay, it's been too long, I'm going to do this. Now, typically, if you have a conversation, they might say, yeah, we're done here. We're not going to give you anything. And then okay, I better move on to a claim.
And so Malmida is asking, should I request EA from the contracting officer first? And if asked, then submit a claim, or both together?
Definitely, you don't want to do both together, right? You want to do one or the other. And so again, it comes back to the, kind of some of those factors we just discussed about whether or not you think an equitable adjustment's a better approach, or the Contract Disputes Act claim is a better approach. Thinking of speed, thinking of how easy it is to work with the particular contracting officer on that contract.
And Chris, this is a separate question, but I'm going to throw this out because I'm just going to tell you, you want to talk to Jason about this one. We're sub to an SDVOSB on a veteran project. We actually have multiple projects with this contractor. In February, they stopped paying us, and we can't get any response from them. Can I take this to the contracting officer with the government? And
so I just kind of briefly, I'll tell you that if you're the sub, you don't have privity with the government. The government may not, because again, privity means who's the contracting party. The government has contracted with the prime. And so they might say, hey, sub, we don't have anything with you. What typically would happen is that you would go to the prime and say, hey, you need to pay us. And if they're like just not responding or telling you to go pound sand, then you can alert the contracting officer. They may try to get that prime to pay you a little bit. It wouldn't be in the form of an REA or a claim, but a lot of times there is a FAR provision for Prompt Payment Act for subs, especially SDVOSBs, and you can bring that up to the contracting officer's attention. That will destroy your relationship with the prime. The prime will be like, what are you doing? You're getting me in trouble with the government. But it might get you paid. And look, if they're not paying you, I don't know how much more work you want to do with them anyway. But if you go through the prime and they're saying go pound sand, then it becomes a dispute between you and the prime contractor. And there are ways to handle that.
There are ways. Yeah, you definitely would talk to Jason on.
Yeah, and we can talk about those.
And I'm hoping that we got the situation solved with being able to get the presentation. But if we haven't, you'll get it, I promise. John saying our pricing, which was not fairly explained at procurement and resulted in extremely skewed task orders, tasking is fixed. We want to lower the price. I'm sure they'll let you lower the price.
I mean, that's something like, again, bring that up to the contracting officer, discuss it, explain why, provide details. And if you're talking about lowering the contract price, the contracting officer will probably be interested to hear that. But again, if I'm happy to chat with you about that to see what it looks like, maybe.
I love this one too. Xerxes, first of all, coolest name ever. 2 X's in your name, just fantastic. I'm seeking an REA due to Executive Order 14026, which increased our payroll in excess of the new wage termination funding. Can you blame the president is the question. That's the real question.
Yeah, that is something you can seek an executive order for. The government has changed the requirements of the contract by requiring you to pay higher wages. Therefore, it's a change to the contract that results in an increased price. So that's perfect for an REA.
Love it. And we're going to get to some of these answers. Again, let's get through this. And I know we're going to run long because we're slide 36 and 66, buddy. So we got to, we'll run long. Don't worry. It's being recorded. If you miss it, you had to jump out. You can jump out, but we don't want to not answer your questions, right, Jason?
That's right. Yeah.
All right. So equitable adjustments, take us.
So here we're back to looking at, hey, what are you trying to do with this? You're trying to get back in the same position as you were prior to the change. So there's a basic formula that's followed, and you look at there, what it would have reasonably cost to perform the work as originally required, and what will it reasonably cost to perform the work as changed. And that's how you're going to do, that's how you're pricing. Whether or not you have an equitable adjustment. Hey, is there an increase? Yes. Okay. Now how do you price it? It's based on that kind of simple formula. Timelines, we discussed this. Formal written changes, it's right in the FAR. You got 30 days if you're going to assert your adjustment. Now, even though it's written 30 days, there's some wiggle room in there. You can see there the CEO may, act on a proposal later on. The courts are generally they don't necessarily hold everyone to the 30-day timeline, but please, 30 days, right? Construction contracts also have some additional, they have some additional specific details they want. And constructive changes, there's no stated time in the rule, but if you follow that 30-day timeline, you're going to be usually you'll be good.
Just do it in 30 days.
Yeah. Be careful about signing releases. When you get these change orders, there's usually going to be something that the government says in there, like when you sign this, by signing this, you agree that there are no claims, there are no, equitable adjustments. There's no this, no that, no this. If you waive it, if you say, yeah, I'm saying there's nothing here, that hurts you later on. That's where if they make you sign something, you put, I am signing this under protest. You literally write, I am signing this under protest on the document. And that sometimes will trigger the contract officer. Okay, wait, maybe there's something here. But you want to reserve the right. So I'm signing under I'm doing this under protest. I reserve the right to file a claim or an equitable adjustment on X, Y, or Z for these reasons.
That is some of the best advice I've heard yet. Is just put it right on there.
Put it right on.
It's just fantastic. All right. Substance.
So, yeah, substance, right? So it's, hey, a positive present intent to seek recovery as a matter of legal right. Okay, first off, put it in writing. It's not required, but do it. If you don't, it's like it's never happened. It has to be more than an ambiguous letter talking about a difference of opinion. And it's not just advising the contracting officer of a change or you think something's happened. You have to seek a recovery. You have to seek some sort of resolution. And that is what makes it into there. So it's right in the FAR, tells you what to put in there. There's no particular form, there's no particular style it has to follow, but it's right there in the FAR. And this is paraphrased. So I would go to that citation there to see what actually is required, because I could not fit everything on the slide and not make it an eye chart. But that gives you the basics. And the problem is, what if you don't have all the information, right? Still submit your claim, your equitable adjustment, but call it an intent to submit within 30 days. Say, hey, I intend to submit an equitable adjustment. I'm gathering all the information. Now, once you have all the information, send it as soon as possible. Again, don't delay. Get it as soon as you can. Try to keep the contracting officer updated on that. And again, timeline. There is not a stated timeline to provide your equitable adjustment after. Like, for example, you do the intent to submit. Great, the contracting officer got it. He's waiting, or she's waiting. There's no other stated timeline, but don't delay. You got to be reasonable on that.
Yep.
And there's the policy on the FAR is to finalize these as quickly as possible. And as we've already seen from the comments in this show, that's not always the case, right?
No way.
Yeah, imagine that. But as we talked about, is key. Remember that the CO must justify his or her decision to approve that change. So you as the contractor should provide all relevant information, evidentiary support that will make it easy for the CO, because when the CO's job is easy, you're going to get what you want, right? So you're going to do that work. It's just like if you want someone to provide you a request for an exception of policy or whatever it might be, if you draft for them what that's supposed to look like, it'll be much easier for them to say, okay, I'm going to take this and run with it.
Oh, and the more you put it into their world language, the better off you are,
right,
all the time.
So pricing, look, we talked a little bit about the pricing rules already. And I mean, I could do a whole week seminar just on pricing equitable adjustments. There's a lot that goes in there. A lot of times you're going to need expert accountants or expert witnesses to justify your pricing. Just know that, look, you're looking at what was the cost for the original performance, what's the cost of the change performance. And again, look at all the categories of your business and see like, hey, did this affect X, Y, or Z? Does this affect X, Y, or Z? And you'll get to your answer. Next slide. So you have to have those increased costs, the cost you've incurred and the cost you will incur, right? So it might not be something that's already occurred yet, and you might have to estimate. You might have to make an estimate, and it has to be reasonable, right? They're objective costs, but they are particularized to the actual contractor and the contractor's business. But the CO has to justify this change. This is not a time to be greedy, and definitely do not supply false information. And that case is this. There's a case site there, Joseph Morton Company. That's a case where false information was provided in the claims process. And not only did the government deny the claim, but that guy spent some time in jail.
Yep.
False Claims Act liability.
We are in jail avoidance mode always.
Yes. So interesting, because the case, it's some very interesting facts, because it's about Plum Island, which is off of the Long Island, New York, and it's about animal testing. And so for like disease prevention and stuff like that. So it's interesting facts on if you have time or the inclination. I know I'm a lawyer nerd, right? So it's interesting to me. Let me show y'all. And don't forget profit, if allowable. There are certain portions of the FAR that allow for additional, allowing for a basic profit or fee, but sometimes it's excluded. So again, think about whether or not you're going to be able to ask for an adjusted profit on that.
Come on, baby, you can do this. There you go.
So the government may delete work and say, hey, we're deleting this work. We're going to lower the amount of the contract. And again, be very careful before you sign something like that. Be sure you look at it very carefully, because a waiver is a waiver. It's gone. You can always say, hey, well, the government said they're going to delete this, but then they actually made us do this work. That could set up a claim. And sometimes what happens is the government will delete some work, add some more in, and it can muddy the water.
It can get hairy. That's a fact. And we had this question as well.
Yep. And then I'll just mention that the last thing is look, a lot of times when you're doing it, when you're a subcontractor and you have a dispute with something the government does, you have to do what's called a pass-through claim. There's something out there called the Severn Doctrine. Again, beyond the scope of this briefing, but just know that pass-through claims by the subcontractor may be limited if the prime is not liable to the sub due to those change in contract terms. So again, if you've got questions about your sub and you're having issues with your prime, we handle prime sub disputes all the time. Happy to chat about that.
Yep. Oh, I already did that. Why is this not working? There we go. All kind of issues. Go ahead. So
after you submit your request, what should happen is a negotiation should happen. And hey, that's either going to result in some sort of settlement or a disagreement. And as we talked about before, failure to agree on an adjustment shall be a dispute under this disputes clause. And that says, hey, now you can file your claim. There's a FAR provision for that as well.
Love it. All right, we are going to ask this, and we'll get to some questions in a few minutes, but I know we are running over. So if there's folks that have to go, just a reminder, this is being recorded. It will be distributed to you. And but if you've had an equitable claim adjustment denied, let us know about that. And what happens if you get denied, Jason Boyd?
Yeah. So look, you're going to, if sometimes the government may be right. They may have some additional information they provide you and you're like, you know what, dang it, I don't have a good claim. There's not a good equitable adjustment here. However, if you're like, no, the government's still wrong. They just like stonewalled me. You can file a claim. And I got the definition of claim there. We've kind of discussed that, but I broke it down in that slide so you can kind of see what it is. Demand, seeking as a matter of right payment of money in a sum certain, which is important, or adjustment to the terms of the contract or other relief, right? So it leaves this catch-all at the end. So next slide.
I love that other relief, because anything that gives like future coming back to this to be able to do adjustments, there's wiggle room in that for both sides. I just love that.
We talked about certifications earlier. This is required by the Contract Disputes Act by statute. It's also in the FAR, but essentially you have to certify it. And there's literally, it's just a phrase you put in at the end of the claim, and someone with authority from the company signs it. So elements, got that sum certain submitted to the contracting officer for a decision, right? And then you're explicitly requesting the contracting officer's final decision.
And that's the verbiage that you want to keep out of
an REA.
REA.
Because otherwise it'll be considered that, right?
That's right.
Or could be considered that.
Mm-hmm.
So again, no particular form, no particular wording, except for that certification. But generally speaking, you're going to have kind of certain elements, right? Hey, the facts in the background, the legal standards, right? So again, if you're doing a claim, I would really highly suggest seeking legal counsel.
Mm-hmm.
But your argument is your claim amount and your certification. And once you have that, then you've got your claim. If it's over 100,000, you got to do the certification. You can look to those sites to get the language. It's supposed to deter fraud. You got to consider the aggregate effect of the increase and decreased costs, whether or not it exceeds that. If it's one set of facts, do one claim, but you can break it down into different sections, right? You can say like, hey, X, for this, 1, 2, 3, one for this one, 1, 2, 3. Don't split a claim up to try to avoid that certification.
Yeah, that would be bad.
First off, the government's gonna be like, this is one claim, you submitted a bad claim, and they're gonna make you either redo it or they're gonna hide in the tall grass and then say, you're late. And that would be bad. But two, you're already signing certain things with this contract. You're already doing things where you're certifying certain information. So to add additional certification, there really isn't that much of a stretch. And again, you're asking the government to pay you money. And if you ask the government to pay you money, it's always going to fall into the False Claims Act. So again, there's no harm in certifying. So I say, why not certify even if it's under $100,000?
Yeah.
It's not going to harm you. Yeah.
I love this one too, the digestible bites piece.
Yeah.
Because if we're in the the business of educating the why this should be. And if you do it in digestible bites, then they can handle it. They're like, and they may go to, well, we like this one, but that part we're going to argue about, but we'll take the bulk because you did a good job of explaining yourself as to how this has affected you and how the change has affected you. And even to the president of the United States, right? So this executive order did that.
That's right.
Yeah, love that idea. Go ahead.
So just breaking down the certification language, right? The claim has to be made in good faith, accurate and complete, accurately reflects, and is submitted by someone who's duly authorized to certify the claim on the contractor's behalf. So you can't have, the mailroom person certify if they have no authority to bind the company, right? You got to go to someone who's got, signature authority.
And some certain means the exact amount. Is that what I'm seeing?
Yes.
That makes sense.
Exactly. Right. The government wants to know exactly how many dollars you want. And guess what? Sometimes it's hard to know, but don't put in, well, at least approximately. All of those terms that I've put in quotes have been claims that have been denied because there was not a sum certain.
These are all been denied?
Yes.
Wow.
So really, please, sum certain, put in an exact dollar figure. But you can see the next kind of bullet point there is, well, what if I only have an estimate? Make an estimate on the best information available. Tell them how you came up with the estimate. Explain the sources that you used. Explain, kind of the methodology in order to come up with this estimate. Because that way the government will be like, okay, I understand why you're doing this. For example, let's say that you have to know. And I was talking about this presentation with a colleague, a short war story. He mentioned that one time he had a client who was making really big kind of machinery to take off tires off like tanks and other big, fighting vehicles. So it's big stuff. And the Army said, we want a maintenance facility constructed somewhere else other than their main construction facility. They had no idea how to price that in a foreign country. So at that time, they went to the newspaper, looked at classified ads, found out how much it would cost to buy certain amounts of land, how much it would cost to hire certain types of employees. And they used that. And he said it sailed right through because it was explained. The estimate was explained why this estimate was good, right? Why we came up with these numbers, how we came up with these facts and figures.
Love it.
So again, sometimes you got to get a little creative on how you price something. Now with the internet and all the information out there, it's probably a little bit easier, but still, sometimes you're left with an estimate. Statute of limitations. This is important. Don't wait forever. But look, you say, I got 6 years from the date the claim accrues. Right? That's a long time. Yes, it is. But don't sit on your haunches and wait till 5 and 11 months. Right? Work quickly to get this done. First off,
I would like to get paid before 6 years. That's my philosophy. I like to fix it.
Yeah. So you have a long time to do it. But if it's, and we'll go through here because there's some other timelines that are very important. Decision timelines, right? So this is what happens. You submit the claim to the contracting officer. Okay. So if you're waiting 5 years and the contract's been over for 4 of those 5 years, is that contracting officer still there? Right. This adds a lot of wrinkles that you don't need to add. But the contracting officer is supposed to issue a final decision on the claim, right? Remember, that's what separates it. You've requested it. You've got 60 days, right? 60 days after that, all right, to assert your appeal. Okay. So what happens if, and again, there's real quick on that, there's a deemed denial. Say the contractor doesn't come back and tell you within 60 days, you can consider that a deemed denial. Okay. Rights advisement. When the contracting officer says, this is my final decision, they will normally put something like this. This is actually out of the FAR, but the FAR says substantially follows. It doesn't have to be exact, right? So be careful because don't get cute with this and think, oh, wait a second, I have additional time here. I have time, because the contracting officer didn't say 90 days, or the contracting officer didn't include some of this information. But again, if you go from contracting officer gives you your final decision, it's going to give you these rights. You have 90 days from the date you receive that decision to go to the Board of Contract Appeals. If you don't want to go to a Board of Contract Appeals, you could go to the Court of Federal Claims. You have 12 months from the date of this decision, right? So those are very important timelines to keep in mind. And I think I misspoke in the last slide, 60 days. It's just contract officer has 60 days. If they go beyond that, right, you can either do a deemed denial, and you can proceed as if on the date of that 60th day, you didn't get it, that would start your 90-day clock, right, to go to the appeal through an appeal process. The final decision is binding and conclusive unless you appeal it. So don't think it's going to get better. You can request reconsideration, but depending on, there could be circumstances where that might be beneficial, but I would just say, hey, look, it's time to appeal this to either the board or the court.
Which gets us to this. So it's been denied. Now, what do you do?
What do you do?
A couple of these already. So go ahead.
Yeah. So you got some forums, and I put a plus there because there's another way to handle this. But one is the Board of Contract Appeals. There's a couple of them out there. Armed Services for all the DoD, civilian for most other agencies, and the Postal Service has its own. The Court of Federal Claims, it's a federal court down here in DC, and it does just that. It handles all the monetary claims against the government. There's also FAR ADR procedures. So you can look at FAR, you can look here, you can look at that site. You can request that this whole process be resolved through alternative dispute resolution, ADR, alternative dispute resolution. And you can request, that, and sometimes the agencies will say yes. For example, the civilian board will normally want the parties to go through an ADR process in order to get there. But you don't have to go through, you can choose any neutral in that process. And that, again, going through all that is kind of beyond the scope. And I know we're already over time, so I'm going to leave it at that as it's another possibility. If you're thinking about doing something like that, actually save time, potentially save money, maybe worth doing. So, reach out and let me know if you think that might be something you want to do. But regardless of which direction you go, it is highly advisable to seek legal advice, because both of these forms, whether it's at the board or the court, they are adversarial. The government's going to come with their agency attorneys. Sometimes they got a lot of agency attorneys, and they're going to fight you tooth and nail. They're going to start sending you deposition requests and interrogatories and requests for discovery. Fun stuff. Yeah, all this junk that you might want to. You want to be there. The DOJ represents people, agencies at COFC. It's the National Court Section. A lot of folks over there. This is what they do, right? And they're there to uphold the government's rights. So I tell you, it's something where seek legal advice at that point if you're going through this process.
Absolutely. And seeking advice is always a good idea. And your advice, like you said, you can reach out to Jason for nothing. Just send him an email.
Yeah, I'll let you know what I think, and if it sounds like, hey, this is something you want to pursue this, then we can take it from there. I'll just say this real quick. Courts and boards, right? So it's the boards, that's what they do. Their whole purpose of existing is to resolve these claims. COFC judges, they do more than just claims. They also do veteran appeal claims. They do a lot of things when people are requesting money from the government, but they usually have a good background in government contracts. Which is interesting, though, the Court of Federal Claims may actually be faster than the Board of Contract Appeals. The ASBCA is notoriously slow. And the COFC, they follow the rules for the Court of Federal Claims, certain timelines in there. They keep things moving a little bit faster. But the COFC is definitely can be more expensive than the Board of Contract Appeals. Both forms kind of do a do-over. They relook de novo the contracting officer's final decision. But each of them have their own precedent, and they don't always match, right? They don't always all rule in the same way. And so, look, it might be more advantageous for one particular issue to go to a board versus to the court, right? And that, again, I'd say you need a lawyer to help you make that decision, because if you're just trying to research cases on Google and try to figure this out, sometimes
don't do that.
Don't do that.
Yeah. Speaking of needing some help, and we're going to get to the questions and get you guys out of here. I'm telling you the truth. I'm going to launch that. I need some help. I want to see if I actually have a claim. I need help filing a request for equitable adjustment or a claim. And there's difference. We learned today that REA versus claim, very important language. At least that's what I learned today, is don't treat them as the same. So if you need any help, let us know, and we'll make sure that Jason gets that. And speaking of Jason, here's his contact information right there, so you can actually talk to him in person if you want to reach out. Sorry. All right, so we got a couple of here and good stuff. And this is the first time we've done this, so we ran a little long. Sorry for giving you too much information as opposed to withholding it. There you go. So, Carla, regarding SCA contracts, the H&W increases have been outpacing our YOY escalations. Is it reasonable to ask for an EA for this contract? Is medical DOD, labor wages also have significantly increased for personnel? So,
I think that that's not unreasonable to ask. I think that is something that, I'm happy to discuss that with you to see whether or not there's something there that we work on. But labor costs go up. Maybe there's something that the government will work on you with.
This is a great one from Brian. It says, what if you have a main multiple year contract with multiple delivery orders? When should I submit for the change? Because you have multiple orders on that same contract.
Yeah. So I would tell you, look, work with the contracting officer. I would let if you think there's a change going on, let the contracting officer know. I would say, look, as soon as you can, because you don't want, if you keep getting more and more orders, that kind of exacerbates this change. You want to let the contracting officer know, hey, I think there's been a change, or I think there's a change that's required, and it may affect order 1, 2, 3, 4, 5. So before we, I want to resolve those, but before we go forward with 6, 7, 8, let's see if you agree that there's some change that needs to be happened to this contract language.
So in the case where the government did not supply complete, coordinated, and buildable construction docs at the outset of the project, which has led to dozens of bulletins and owner requests for RFPs, but with no added time to the contract, can we cite the Spearin doctrine in making a claim for costs and added performance? They have 3 years that have been shot down so far. This comes from Aaron.
Yeah.
Talk to Aaron.
I think that might be best to talk about offline, considering where we are in the presentation. But I'm happy to help you with that.
So can we ask for REA for inflation on T&M?
You can, but will the government actually give it to you is the question. So if you can go through and say, because it depends on what the contract, all these contracts, they have certain terms, they incorporate certain clauses. It's possible, and it might be worth pursuing. But Patricia, I'd be happy to talk with you about that, because it's hard to say in a blanket statement whether yes, you can, but how successful would you be, and it'd be worth your time or not.
Speaking of success, William says, an additional option in REA quiz, we received less than 10% of our requested additional costs. So there you have it.
So I would say, look, that's why it's important to think about when you sign that 10%, if they say, hey, we'll give you this additional 10%, but you got to sign this document. What did that document tell you? Did it say you're waiving the other things, or did it still going to allow you to pursue that other 90% that they didn't provide? Because if you waive that away, it'll sometimes be very difficult to get that back. But if it's still an opening to go after the other 90, you can also submit a contract claim. So if you only get a partial resolution of your REA, you still have a claim because you're still disputing the other 90%.
Yep. So Patricia says, if so this goes back to the T&M, what FAR covers that? Do you know?
Yeah, well, I would have to look at the FAR.
Yeah, look at that.
Yeah.
So Patricia, reach out and shake him down for that. All right. So John, is there any specific form that the REA would take? Is it simply a letter with support documentation attached?
Yeah, there is no form.
No form.
It is it is a letter. I'd say obviously a very formal letter. We have a kind of like how I went through on slides, take facts, background of the contract. Here's the issue, legal arguments, right? That's how it would usually flow. But just don't ask for the contracting officer's final decision.
Yep. And Chip, you're going to want to talk to Jason about this one, because he also works in security clearances, and he can talk about security delays, technical hurdles that hold up the team that you still have to pay. And the government tells them they're not paying us for time. Is it not feasible to pull resources off the project then back on? Of course. So do you have any options, Chip? You got to talk to Jason.
Yeah.
Definitely do that, because we just sent in our first REA.
Hey, congrats.
Congratulations. In our contract with FAA, the CO and the Corps sat on the multiple RFIs that were submitted. The information from the CO and core was needed for submittals. In the meantime, the CO issued us a notice for non-performance.
Whoa.
How to negotiate such a situation. Momita, pick up the phone.
Yeah. Please get in touch with me, because
that's one that you want to
issue of non-performance is not
don't
good.
jack around.
Because if that's stylized as a cure notice, the government's going to try to terminate you for default.
Yep.
You don't want that.
You don't need that.
Yeah.
And that's not going to help you ever.
That's not going to help you at all.
At all. All right, Matt Anderson, are there any special considerations that I should make if the REA claim I want to file is against an OTA?
So yeah, the other transactional authority they have, it's its own animal. So no one necessarily follow the FAR. I would have to look at that specifically to see if there's any other requirements under the OTA kind of guidelines and regulations.
I love Enrique. He talks in your words. Listen to this. I'm closing a contract that started in 2019. Could we submit an REA or claim additional costs and extended overhead due to COVID-19 pandemic and labor shortage? Or is this force majeure? That's what I was saying. Is usually considered non-compensable.
Compensable.
Both of those are legal terms. Man, I'm lucky I could even say those. I couldn't even.
There you go. Well, I will tell you that I'd love to take a look. I think it is possible. I think people have been submitting REAs or claims based on COVID-19. But it is, the success rates vary wildly. So it's we can take a look and we can look at the terms of that particular contract and what you're providing, the work you're performing, and seeing if it's something that would be worthwhile to pursue.
Right on. And can we resubmit an REA that was already sent in? Great question, bro.
Yes, you can. You can submit. You can resubmit, but at some point, the government's already already thrown down their dice, right? They're not gonna, if you've got some, hey, you denied for, say the government comes back, we're denying your REA, and they provide you a reason for X, Y, and Z, and you want to respond back like, oh yeah, but here's the answers to X, Y, and Z. You want to keep it in the REA lane? Absolutely. But at some point, the government's just going to say, just file a claim, right? Well, they're not going to tell you that, but that's what they're telling you by their actions.
They're going to do that.
Yeah.
All right. So Alice has a great question. How far in advance can you request an REA when the wage determination will change in a couple of months? I love this question. Well, I cannot wait to hear what this is.
You can submit it in advance. If you have information that the wage determination is going to change, you can submit it and say, hey, the wage determination is going to change. It's going to increase the wages of these labor categories on this contract by this amount. And based on the hours that we're going to have these employees work, we believe that the contract needs to be adjusted by X number of dollars. So yes, you can do it in advance. How far in advance? Again, it varies. There's no stated timeline that says how you must do it. You can only submit something, 90 days in advance or whatever. So you can, but it just depends on how much that CO is going to pay attention to a really, really early REA. And they may come back and say, hey, submit it when you've got costs that you've incurred, for example. They may not want to try to handle this proactively, but yet say, hey, incur the costs first, then come back to us and ask for an increase in price. Just depends on the CO. And
I love that earlier communication. To me, always makes sense to be able to say, hey, we got something coming down. And then you're kind of asking the question, what's the best way to handle this? I don't want to put you in the hot seat. I don't want to do all this claims crap. What can we do proactively right now to try to solve the problem before it becomes a problem for either one of us? Because once it becomes a problem, then you have the walls of defense and you have, additional pieces. So awesome, man. And so I don't know, there's one more Q&A that somebody popped in here last minute. Can you submit a REA for CBA wage increases? Man, all kind of acronyms here.
Yeah. So, if you have a collective bargaining agreement.
There you go.
Right. So if the CBA rates go up and the contract requires you to pay the CBA rates, that's possible to do an REA on that. and again, in this age of inflation, if wages keep going up, the executive orders increasing wages, yes, those are areas you can do it. So look, happy to chat about those if you want to connect.
Yeah, and you get to blame the president. Oh man. Oh yeah. So stay away from the third rail of politics, everybody, just like I didn't. But hey, Jason, good stuff, man. This is the first time we've ever done this one. Obviously, there's a lot of interest challenges with this. My anticipation that we're going to probably do this again. Everybody will receive. There's a couple of things you didn't even know for those of you who are still here listening. One, you will get the recording. Two, you will make sure we get the presentation to you the way it's supposed to be if you don't have it already. And third, you can come to Monday roundtables where we can continue to dialogue on things like this, as well as other business development and other situations that we continually do. So you are welcome. You didn't know that when you came. Jason's there sometimes. I'm there most of the time. Somebody on my team, some other team members to help. It is group therapy for federal contractors oftentimes, and there's a couch for everybody, including me sometimes being on it, because this is a freaking nutcase place to try to do business, isn't it, Jason?
It can be. It definitely can be.
It can be. But I tell you what, man, great job. Again, really appreciate the knowledge transfer. And please reach out to Jason. As he said, hey, he's here to help. And he's just not your typical lawyer guy. He's willing to talk. And when it starts incurring time, then it starts incurring pay. But there's so
at some point, I can't do it all for free, right?
Can't do it all for free,
so. But we have very reasonable rates, considering the kind of the going rate in DC. Yeah. But if you're there's some other firms that maybe not in the DC area that but I mean, full disclosure, they could probably beat us on rates. But do they have the experience that we have? Do they have the ability to do the job that we can do?
I've been around here long enough, and I know folks that are playing in your pool. Always love what you have to say. You don't hold anything back, and you do the best you can to try to help people all the time. So I appreciate that, man. Thanks again. And you will receive the recap email shortly. I got to jump because I have another briefing I got to start in 30 minutes. So let's see.
See ya. Thanks.